Hey guys, welcome back to Legally Speaking with Rest the Case. And today we have with us Advocate Rohit Singh, who specializes with commercial and many other company and commercial issues. And today with him, we are going to discuss about how mediation and arbitration can transform the Indian judicial system and make their cases less and their burden less as well. So welcome to our show, Mr. Rohit Singh. We are very happy to have you here.
Likewise. Thank you so much for having me over.
So how are you doing today?
Absolutely fine. And I hope the same for you as well.
So first, let's get started with what is mediation and arbitration for the people. What does mediation and arbitration mean? So according to what I have researched, mediation, yeah.
Please.
So according to what I have researched, mediation is something which can be resolved between two parties, and there's a mediator, and they come to a common ground and get a result. While arbitration, there is a arbitrator who acts as a judge, and the two parties offer and like show all sorts of evidence and arguments in front of them, and then the judge gives a verdict. So these are the two things that I have researched. What would you like to add to that?
See, essentially, I would say that in a layman's language, you have essentially covered almost everything. And kudos to the research that you have done.
Yeah.
But bringing this discussion a little further on its technicalities, I would say that before we understand these two facets, there is this essential part that we need to understand what the ADR process is. So ADR is basically an alternate dispute resolution. Like the name suggests, ADR is nothing but an alternative method by means of which anybody, not just a company, not just an MSME, not just an individual, anybody who has any dispute, he doesn't have to wait in those long queues. He doesn't have to wait for those months. He doesn't have to wait for anything. He can just simply apply for a mediation, arbitration, or conciliation. So this can be broadly categorized. Any ADR method can be broadly categorized into three categories. One is obviously arbitration, which is very widely recognized method of resolving disputes, not just for companies, but it becomes rather the most important factor whenever we are entering into international contracts, because nobody wants to come to your country and contest the matter. So whenever we are into international contracts, I have been into that scenario that it is rather the most troublesome work, that how do we decide onto the jurisdiction. So arbitration, for that has become the need of the hour when it comes to the international contracts, right? Second is mediation. Mediation, I would say, is my personal favorite. Why I say so? Because I, coming from a very corporate side of background, since I've been working with corporates half of my professional life, wherein I worked with Reliance, I worked with former Additional Solicitor General of India. He has been taking up more than 2 lakh commercial matters per annum. So when I talk about those numbers, why I say mediation is my favorite, because that saves me a lot of legwork, not just for me, but for my clients as well. Now, having said that, mediation comes with the biggest benefit of all, which says that you don't have to get involved in the lengthy process. Even in arbitration, you have to file a statement of claim. You have to file a statement of defense. You have to read evidence. You have to have arguments. Then again, you have to seek dates. In mediation, everything gets bypassed. You simply take a date from the mediator. You appoint a neutral party. You ask them to give them some, to give them some suggestions. You ask them that they become the neutral party and suggest you that how the things are going. And even the mediator, sometimes they help you suggest that what laws favor you and what laws doesn't. So in a way, he even guides you that even if you go 10 years down the line for this matter, you will not get more than this much amount, or you will not get better than this resolution what the opposite party is offering. So mediation, I would say, for anybody who is actually going for a quick fire result rather than going into a long standing litigation, mediation is the is actually the way forward.
So mediation is like basically a consultation between the two parties, like how a lawyer and a client is consulting. But here in this case, they're like they are consulting, taking suggestions, and getting to a common conclusion what preferably might happen.
You can say so, but to talk about the differentiating factors between the arbitration and mediation, I would formerly say you will have a result over outcome. When you are going for an arbitration, you don't have
Mm-hmm.
any result over the outcome. The arbitrator says sun rises from the west, and so be the case.
Yeah.
But
Yeah.
then again, there is a judicial process that you can challenge it under Section 34. You can challenge it under various sections, and you still have rights to go for a higher court and file an appeal. But then again,
Mm-hmm.
you are stuck in the same litigation scenario.
Mm-hmm.
When I say that in mediation, you have a control over the outcome. So, say if I'll just give you an example. I would say that I have been handling more than 750 commercial disputes in last 3 years or so, post the COVID era. Out of 750 cases, I would say more than 600 cases I've settled through mediation. And trust me, that is a very big number. When I say why I say these numbers, when I say why I say these numbers, see, it's a basic average that I take for myself. I say that if I have to do 600, that simply means that if I divide it by 12, or if I divide it by 24, if I divide by 36, these are the number of months that I've invested. So another benefit that I would say, I don't have to remain shut in June because of court vacations not to do mediation. I can still do mediation even if the courts are shut. So I'm not waiting for any judicial officer in this case. Though I respect the judicial officers, but they are also bound down by the timings that they have. A few months earlier, there is a fact that came to my notice that there are over I believe 20 crore cases that are still pending for just Negotiable Instruments Act, for just check dishonor. And when I say that being the number, I believe that in every household there is a case that is going on for a check dishonor. Right. So all of that can be just bypassed in a moment when I say that somebody just has to appoint a mediator, and even the mediation process, I would say, is actually going rapid fire. It's growing to an extent that in today's time, you just take any commercial dispute under Commercial Court Act under Section 2, you go to a mediation center, file your application under pre-institution mediation, which rather is actually the statute that you have to go for a pre-institution mediation before filing any commercial matter before a Commercial Court Act. So you just simply file a pre-institution mediation application. The mediator gives you maximum 7 days of date. And if you have good connects, he might just give you a date sooner than that. So if there is a good lawyer who is representing you, he'll get you the date at the soonest. The next very moment you have a date, you sit across the table. So not just that, I have settled matters with Air India, Samsung. There are big names in the industry. So they don't want to necessarily litigate with you. They just want to help you out at the earliest, and they just want to quickly resolve the matter. And the best way to do so is not, thrashing them left, right, and center before a court of law, and then some journalist capturing it, and then on the next day you see it on a cover page of the magazine that Air India is in dispute with this XYZ party, and they have just done injustice. They simply want, I'll give you 10 lakh rupees. There is a dispute regarding airlines, I'll give you 10 lakh rupees plus airfare, whatever it costed you. You just simply leave me and tell me what is the price. And you just want it to happen at the soonest. You just don't want people to get conditioned with litigation. So whether it is companies or anybody, ADR, I would say it has many differentiating factors. To talk about the least, obviously, like I said, control over the outcome. Then formal and the procedure that is followed in an arbitration is a little bit on the formal side, which is relatively far lesser formal when it comes to mediation. The biggest benefit of all, whatever you discuss in a mediation doesn't get recorded at all. And it can't be before a court of law. That can't be put against me before a court of law. So discussions are confidential.
That part you said about confidentiality got missed in network. Can you repeat it?
Okay, I'll repeat it again. Sure. So like I said, the biggest benefit of all is that whatever proceedings are happening during the mediation process, or the conciliation process. In both these processes, your discussions, they can't be taken up against you in a court of law. So even if you have admitted your mistake out and loud, even if you've said, yes, I am the one who has taken away this money, I've received your goods, I have received all the obligations from your side, I'm not ready to pay the money. Even then, this admission can't be taken up to the courts that this person has admitted the same thing during mediation process. So there is a confidentiality and there is a ease that comes out of mediation. So people, sometimes I would say that people just don't necessarily discuss. I would say half of those disputes can get eased out even without a lawyer if the parties are ready to listen and talk. But when there are big companies, there are big egos, and there are parties involved, they want some mediator to come up. That is where mediation comes into the picture. And necessarily, I would say it saves a lot of time. And because even if I tell you about my fees, I don't want to quote even if I say so. So I literally charge 50% of my fees if I'm going for a mediation and a conciliation process. Sometimes even 30% I charge of my entire fees if the matter gets settled just in mediation. My entire fees, and I'm ready to do the mediation. And if it gets settled in mediation, I'll charge only that much. The rest 70% of my bill gets waived off. So that's basically just my outlook. So obviously, time is money in today's era. When you're talking about commercial disputes, time is money. You save time, you can make more money out of it. So there was a matter that I was arguing yesterday. There was a company in Pakistan. Obviously, I can't take names, and that company had an understanding with my company, with my client's company, which is in India. Obviously, they had no arbitration clause. So they had to come all the way from Karachi to Delhi. That was way back in 2016. This matter got filed. And when I say it was 2016, the matter was filed, you can obviously have a gauge that it has been more than 7 years that they have been contesting. Still, the matter is pending before district courts. It has still not reached high courts. And I can still assure it will take another 3 months for even the judge to listen to both the parties, because there are travel restrictions for people of Pakistan to get a visa here and contest the matter. More importantly, had there been an arbitration, just the way we are having this podcast, we could have had this matter settled long ago by way of a VC.
I think arbitration
Cost
can be
wise,
very helpful
your
for,
airfare and everything.
as you said, for international issues as well. Like
cross-border transactions.
You don't have to wait.
When you're having cross-border transactions, that gets saved.
So
exactly my point.
There are like,
and then again, I would say,
continue.
Please.
Okay.
So I'm saying, then again, you can say that the eventual part that comes in this whole process that we want to drop down to is how do we ensure the enforceability, right? The biggest challenge is that even if there is a mediation agreement that has been effected between the parties, or even if there is an arbitral award that has been passed, is there an enforceability deficit that is there? I would say absolutely not. Just the way a district judge or a civil judge has passed an order pertaining to a dispute, if an arbitrator passes an award, that can be enforced and you can directly file an execution.
Okay.
And to everybody's utmost surprise, there is actually a statutory limit within which the arbitral matter has to be adjudicated by the arbitrator. So if the arbitrator is not able to adjudicate the matter beyond a certain period of months, then he has to take he has to seek an exemption, and he has to tell the reason why there has been a delay. So you get this whole thing done within a period of 12 months necessarily. And then you have an award which you can execute before any court of law, and that's your eureka moment.
Yeah. So what kind of cases usually happen in mediation and arbitration, apart from, like, as you said, the big companies, they choose this option rather than going to court. Apart from these cases, what other cases like people can opt for rather than waiting for these infinite number of dates for courts?
See, I would say that there is a whole act which now has been designed, which I would say is Commercial Sport Act. which pertains to everything under Section 2G. You can just go for it. There are all sorts of dispute. There is a lack of, there is some deficiency in goods and services. You can go for it. There is some payment. There is a mercantile agreement that is between two parties. There is a commercial understanding between two parties. There is a recovery of money that is there. There are intellectual property disputes, somebody infringing your trademark, copyrights, or patents. Anything regarding that,
Yeah.
you can straight away go to. So, in a layman's term, I would just define it. You have a commercial transaction, we can be your lawyer to put it within that framework of Section 2 of Commercial Court Act and put it before the pre-institution mediation before the before the authorities. There will be a mediator that will be appointed by the mediation center itself, and that's it. And you talk about the cost, because that is also necessary for the people who are listening to this. There's just 10,000 rupees of cost that needs to be paid.
So it's very cost effective as well, like rather than going to the court.
Rather inexpensive. I would say it's just, you're getting your reliefs for nothing. Because the matters that I'm referring to are running in several lakhs.
Yeah.
Yeah. It's just that people are more fond of going with conventional methods.
Yeah. Because this process is not like not known to a lot of people that they can save a lot of time and money with mediation or arbitration.
Absolutely.
And
absolutely.
Then there's this major thing that came, which was the mediation bill in 2021, which was passed in August 2023, but it still is awaiting presidential assent, if I'm not wrong. So they say that the bill, the mediation process has to be completed in 180 days, and it is it was then reduced to 120 days, and for extension for another 60 days. So was there a time limit before like this mediation bill came, or was it defined just now that it has to be completed in this time frame?
See, always whenever there is mediation, there is always this timeline that is running in the minds of a mediator. Because you see, you cannot have a mediation going on forever, because justice delayed is justice denied. Like we all know. So even if there is something that, in the similar manner, when I give the same 5 lakh rupees to you over 5 years, right, down the line. So the same is the concept with justice as well. Initially as well, mediation had some timelines. But then again, I would say different people, different mindsets, different theories, and different outcomes. So some people were having this mindset that I will not be giving you more than 3 to 4 hearings. That is when I talk about Commercial Code Act, that there is a foundation that you can't have more than 4, or there is a statutory guidelines that you can't have endless hearings. Okay. If you have missed out on 3 to 4 opportunities, the case has to be stopped from the mediation part, and there is a non-starter report that has to be issued, and you have to be given a clean sheet to go to the courts and contest your matter. But then again, I would say if there is an informal mediation that is going on, sometimes there was no end to it. So that these hearings can happen within 2 weeks or 3 weeks or 4 weeks. So there can be 4 hearings, but those 4 hearings can happen over a period of 12 months. So then again, the whole purpose is futile.
Yeah.
Correct. Now, with this bill coming into the picture, like I said, for arbitration, there was a statute, I would still say, in tedious matters, even in mediation, it will take more than 120 days sometimes. But at least there is some guidelines that are there to 60 days process. If there is something that is stuck up on the final phase, it takes 60 more days and get this resolved. But initially, there was no formal method with which somebody can draw a yardstick that how many days it has to take. Everybody was having a different mindset. Somebody was saying, okay, 60 days of time.
So this was,
I'll not give them.
This was basically a general deadline which was given through the bill that you have to complete it in these few days. Yeah. So
Yeah,
there
yeah,
have been something called as fast track courts um,
right.
to resolve cases. So how is that different from mediation or arbitration? Like, so they are also doing the same thing, but like, do they take more time than mediation, or are they faster?
I would say that is a very, very smart question, first of all, because you see, it is actually the Achilles heel of law. Now, I would just tell something about the Achilles and then I'll relate it with the case in hand. So,
Yeah.
Achilles was one hell of a fighter. Yeah, he never lost a battle. And
Mm,
we all know that there was just one arrow that hit his heel, and that was not even during
mm,
while he was fighting. He was
mm,
saving somebody, and that arrow hit his heel, and he lost his life. He never lost a single battle in his whole life. So that was Achilles.
mm,
And now I'll relate it with a case in hand. The Achilles heel of law is that law is flawless. And
mm,
everybody, while reading the law, we fall in love with it. That exactly this is what we want. This will give us remedy. This will give us solution. But when I put in the
mm,
numbers, and the numbers when I talk about in India, they run in several crores. Like I said, for
mm,
Negotiable Instruments Act, I talk about commercial disputes. You will not believe that in today's
mm,
time, you go to a district court, you go to a higher court. Sometimes you will not even get your matter listed before the court. Even if it is listed today, it will not be heard
mm.
because of paucity of
Okay.
time. So my matter was
Mm,
listed today, for example. I went to the courts.
mm,
Yeah. I was already all geared up that today the justice will be granted and today I'll get everything for my client. In the evening, I'm coming back
mm,
and giving an update to my clients that sorry, your matter could not be heard by the learned judges since the matters
mm,
that were already there in the courts,
mm,
they were of high priority and the judge could not even reach
mm.
our number. So,
Oh.
being such the pendency which we have in courts, fast track courts can't actually give the similar outcome to everybody. So, see, if a court is
Mm,
adjudicating a matter between you, me, or a third party,
mm,
they will have to have a uniformity, they will have to have that unbiasedness, and they will have to be impartial, right?
mm. Yeah.
Imagine there are 10 crores of people who want impartial adjudication of a dispute. How will you give them justice all at once within a period of 12 months?
Mm,
Can you ensure that?
mm.
And then you have limited
Yeah.
number of judges.
Yeah.
So that's the challenge. When it comes to fast track courts, they have law that you have to.
Mm,
So with arbitration, there is law. There is negotiable instrument. There is law. The recoveries there are certain there are rules and regulations. When it comes to commercial court act, there is rules and
mm,
regulations. But all of it get tossed.
mm,
When I say there are more
mm,
than 100 cases registered today,
mm. Yeah.
if I go to a judge and I say, sir, aaj aapki, for example, in today's time, you tell no, but not everybody is getting justice today. Somebody has to
Mm,
wait for tomorrow. And the whole
mm,
statutory guidelines, they get stretched with each
mm.
passing day. With
Yeah.
mediation,
Yeah.
you and I can simply sit at a coffee shop, ask the mediator to come over. I will
Mm,
ask him that these are the outlines within which I want to talk about. I can capture my
mm,
understanding within no time by a lawyer. And
mm,
I can just draw my
mm,
contract, ask him to make amends,
mm.
and then and there itself, we have achieved the settlement, which is binding by the law, practical rather than the statutory guidelines that have been put for fast track courts.
Sorry, I missed the last part.
So I'm saying that obviously these fast track courts, there is statute for that. But yet again, I would say the ADR method, that is the arbitration mediation, they're far
Mm,
more practical
mm,
and they're far more, I would say they'll be able to reach the masses when you compare them with fast track courts. Because even you say that
yeah.
the rape and these heinous crimes which you see in the country in today's time, they are also
Mm,
supposed to be done in a fast track manner. I hope we all know that.
mm, yeah.
But like, were we even in our history, were we even able to give justice to those people who have been victims of such heinous crimes? We all have
Yeah,
seen
that's
heinous
really,
crimes. We all have heard of it. There are Nirbhaya cases.
yeah,
Every day we see and we hear matters which are very close to such rape matters, heinous to an extent that you'll not be able to hear it and we can't be even discussing it in this podcast. But
mm,
can you give them fast track justice? When you can't give them fast track justice, then how do you expect that in a commercial transaction?
mm,
So I'd say that in today's time, it is need of the hour that you sit yourself, discuss it with the opposite party, close it then and there.
mm, yeah. So this meeting is going to end in 3 minutes. I'm just pausing this. You can join the same link again. Hey guys, welcome back to Legally Speaking with Rest the Case. And today we have with us Advocate Rohit Singh, who specializes with commercial and many other company and commercial issues. And today with him, okay, so coming to the
Yes, please.
last part of our discussion is online arbitration and mediation. So since
Please.
lockdown, there have been court proceedings on Zoom meetings like we are doing one right now. So has this made the process of mediation and arbitration much more flexible and easier? And like, what is the future of digital technology in arbitration and mediation?
See, I would say that not just, I would say it has become more fast track when it comes to, we were discussing in our last segment that how we can make it fast track. So, whether the traffic is there in Mumbai or in Bangalore or in Delhi or in any metropolitan, it's horrible. When we go and we consume half of a day in one particular case, you can't be doing multiple cases in a span of
Mm,
6 to 8 hours. Sadly, the working hours are
mm,
still limited, and necessarily all the cases have to be listed quick fire. Otherwise, they, they lose their grip on, and obviously, with the help of the court staff and the arbitrator staff and the mediators as well, everybody contributing their bit to digitalize a little. Because
mm,
not just that, even the files nowadays, the orders nowadays, everything has become available online.
mm,
So by means of which, everything, every single step of the way, you just can't cut down one segment of the entire judicial process and say, now we digitalize this and the rest remains the
mm.
same and the process digitalized and we can expect fast track results.
Yeah.
No, the entire process, right
Mm,
from the moment go till the very end, has to be digitalized to give you some expeditious results,
mm,
which in this particular case has happened.
yeah.
Although it happened when push came to
Okay.
shove, so
Yeah.
we had to digitalize when there was this COVID segment that hit us in 2020. Everything came to
Mm,
a standstill,
mm.
and
Hello.
the,
Hello.
which that way we work until way, otherwise things won't happen at all. Can you hear me?
Ah, yeah,
Yeah, can you hear me
I
now?
stand still.
Okay. So since everything during the COVID time came to a standstill, likewise, even the
Mm,
judicial system came to a standstill. That was a time when everything had to be digitalized. And in today's time, I would say there is just this way with which you can expect quicker results. Otherwise, even if
mm,
there is mediation and conciliation and arbitration working in place, there will be some cases wherein I was talking about cross border transactions,
mm,
international contracts,
mm,
wherein arbitration is helpful. But still, to make it more effective, the only way is that a lawyer sitting in Delhi, having a matter in Bangalore, the party belonging
mm.
from, you can say for that matter, from Mumbai, we can all join on a
Yeah,
similar platform. And
yeah.
without wasting much of time and money, we can still get
Mm,
results.
yeah,
So now, at least no longer check my schedule when it comes to virtual meetings. I simply say you fix a day and everything can be accommodated. That
yeah.
is the
It makes it much,
flexibility you get, whether it is this
yeah, it makes
podcast
it much
or if
more
it is a court
flexible.
session. Everything becomes much more
Yeah,
easier. So you don't have to
yeah,
travel.
yeah,
You don't have to spend much
yeah.
in
Mm,
interstate traveling.
mm.
And
It is very, environment
that
friendly as well, I
is
feel.
the
Like,
only way that you can expedite the process.
yeah. It is sustainable as
Absolutely.
well. It reduces
See,
carbon.
eventually, I would say eventually all the methods have to come to a sustainable method. Sadly,
Mm,
it took us more than 70 years, or rather 73 years, for us to digitalize. But
mm,
last but not the least, it happened. I would say,
yeah.
thanks to COVID, in certain way, that thanks to COVID, this happened. This was
Mm,
supposed to happen somewhere down the line, but it,
mm,
it just happened overnight because everything was shut down and everybody
mm,
had time.
mm,
So they just digitalized it. At least in my office, all my files, which I started off my own practice, to date, all the files are digitalized only in this time. Similarly,
mm,
for courts as well, they digitalized the entire process before proceeding with virtual hearings.
mm.
So papers were kept somewhere else, the files were kept somewhere else. You are sitting somewhere else, and still you can, you can
Yeah.
impart justice.
Access
That
that.
is the way forward that
Yeah.
I at least see the judicial process.
Mm, definitely. So, for the audience, I had taken note of statistics about mediation that in 2005 and 2007, there were many mediation centers that were set up in Delhi and Bangalore. And out of that, there were some 30,000 cases that were given to uh, these mediation centers to resolve, and they were able to resolve over 60% of the cases. And as we heard from you as well, that you had resolved so many cases in so little time. So I think overall, it is a very effective way to get ahead without going to the courts and waiting for the dates. And not many
Correct.
people know about it. There has to be a bit of awareness about mediation and arbitration. So, yeah, and concluding with the podcast episode, I think this was a very insightful talk with you about mediation and arbitration. And I hope you had a great discussion as well with us.
Yeah, it was a pleasure. And see,
And
I would just request that by your forum or by some medium, if we are actually able to spread the word that it
yeah,
is not no longer needed that you litigate over everything.
yeah.
It is actually need of the hour that is switched to an ADR method.
हम्म, कि बैठ के बात भी हो
It is the
सकती है
result
कोर्ट में जाने की
that
हमें
matters. It is
जरूरत
not
नहीं है.
the process with which you want to focus on.
Yeah. So yeah, I was just saying that बैठ के भी बात करके मामला सुलझाया जा सकता है, हमेशा कोर्ट में जाने की भी जरूरत नहीं होती. So yeah, so
Absolutely.
yeah, so it was great talking to you, and we hope that we catch up with you again on
Likewise.
our podcast very soon. So yeah,